Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. Welcome to this morning's webinar where we're going to be discussing basics of the Pennsylvania Sunshine Act, otherwise referred to as Pennsylvania's Open Meetings Law. A couple preliminaries before we dive into the subject matter here. First, if you've never participated in one of these webinars before, it's essentially a PowerPoint presentation with me talking in the background. If you're interested in having a copy of the slides, they are available on the Office of Open Records website, and the address is on your screen right now. You go over to the training tab and scroll down, and you can find a reference to the presentations. And there you'll find all of the PowerPoints that we use for training. You're welcome to any of those. Let's say that maybe you have a colleague who couldn't attend this morning and they want some materials. You're welcome to use them for that. Maybe you're conducting some local training. Again, feel free to download those. We consider them public records, and you're welcome to use those as you see fit. Also, this session is being recorded. So if you're interested in the recording, after a couple days, it gets posted to a YouTube site, and then there's typically a link on our website to that YouTube video, and same conditions apply. If you need it for just your own future reference, if you have a colleague who wasn't able to attend this morning, if you're conducting some local training, feel free to reference that video and use it as you see fit. Finally, let's talk about questions. If during the presentation here today you have questions, you can type them in the chat feature, and I will do my best to answer them live as we're proceeding through the presentation. Two things, though. First, we're talking about the Sunshine Act, so let's keep our questions on point on that topic, and we'll be fine. Second, if you could keep them as succinct and brief as possible, that would also prove helpful. Honestly, every now and then someone will type in several paragraphs, and it's just awkward for me to sit here and read through that while everyone else is waiting patiently. If it looks like you have, something unusually complex or maybe just specific to your particular situation, we'll do one of two things. We'll wait until the end of the presentation, and I'll come back to your question and do my best to get you steered in the right direction, or we'll take the conversation offline. The contact information for our office is on the screen right now. Feel free to call in or shoot us an email. It first comes to our administrative staff, who are very well versed in the law, and they'll try and help you out. And if it stumps them, then we'll escalate it up to some senior staff, and we'll do our best to get back to you within a day. That's our standard, because we figure if you're contacting us, it's probably time sensitive. So we'll do our best for a quick turnaround there. Okay, so that's all the preliminaries. Let's go ahead and dive into the topic, basics of the Sunshine Act. First offhand, I think we need to cover why is the Sunshine Act important at all. Okay, like I indicated earlier, it's also referred to commonly as the Open Meetings Law in Pennsylvania. I want to read from the preamble to that law, so just bear with me here real quick, but I think it effectively speaks to why this is so important, and it's the right of the public to be present at all meetings of agencies and to witness the deliberation, policy formulation, decision making. And it's important because it really cuts to the quick of the democratic process. And that if we have our public officials meeting in secret and conducting business in secret outside of the public eye, that's when bad things happen. So by shedding light, by shedding, sunshine on the workings of government, it ensures a democratic process and a democratic society. Yeah, I know that sounds very altruistic. This was written over 70 years ago. But, when you take a step back and look at the functioning of government and the fact that, these are our elected officials, we put them in charge, it's an important check and balance. in our government system that allows the public, people like you and me, to not only witness, but to participate in how government functions. Having open meetings is critical to allowing all of that. So I like to describe the tenets of the Sunshine Act as a three-legged stool. When someone calls into our office or they send us an email and they're asking questions, was this meeting legal? Should I file suit? Should I take some sort of legal action against my elected officials? We look for three things. First, was there advance notice and instructions on how to attend the meeting, whether it be a physical meeting or whether there was an online presence? Is the public, were they afforded the opportunity to observe the deliberations? And we'll talk about what deliberations are. And then finally, was there an opportunity to comment before our public officials prior to any decisions being taken? Okay, and we're going to talk about each one of these three legs of the stool as we move through the presentation. So let's do just that. First offhand, I think it's important to discuss exactly who is covered by the Sunshine Act, because not all entities are subject to the Act. But let's take a look at the Act itself in the definition section. Whenever you're trying to figure out how a law works, let's say you're reading it and the language is a little vague, it's not entirely clear to you, maybe it appears that there is conflicting language within the Act itself. I always recommend taking a look at the definition section of that particular law, because oftentimes that will provide clarity. It will shed light on the language that perhaps you don't understand. And my experience is that the Sunshine Act is no different. Okay, so this is taken out of that definition section as to who is covered by the law. It applies to any state or local government body and all committees. Now notice committees is italicized because there's not full agreement on exactly what that means, whether a committee is covered or not. But, we're going to discuss that in a little bit of greater detail here. Okay, and then the definition builds upon the prior phrase, that performs an essential government function. Okay, that phrase, essential government function, is somewhat subjective, but let's talk about that a little bit. What is an essential government function? Well, let's talk about what isn't, and I'll give you an example here. Let's say we have a township where the local girls softball team has worked really hard and they've won the state championship. And the township supervisors decide, well, we need to recognize this accomplishment in the community. So we're going to have a parade, and then we're going to have like a gathering at the township park afterwards to recognize the efforts of the girls softball team. So we're going to appoint an ad hoc committee. They're going to oversee the organization of the parade, to get the local fire companies involved and community leaders, community organizations and the like. And then they're going to organize, the gathering at the township park. Maybe we'll have a barbecue. The coaches can give some speeches and maybe some awards and the like. Okay, now, as significant as this accomplishment is, we don't want to take away from the fact that the girls softball team has won the state championship. I think you could successfully argue that having a parade, having a gathering at the township park is not an essential government function. You're not going to find an ordinance or statute anywhere that says if they win the state championship, you must have a parade, you must have a recognition ceremony at the township park, okay? But if we change that up a little bit, actually, let's change it up significantly here. Let's say that there is a standing committee in the township that periodically reviews all statutes and ordinances to ensure that they're relevant, that the language is up to date, that there's no conflict with other state or federal law, and that they periodically will come back to the township supervisors, providing recommendations on courses of action that we should take to revise our ordinances, maybe delete some, maybe add some and the like. Well, you'll find that that is grounded in statute and that it would be considered an essential government function. So between those two examples, I think you could argue that the first, the meetings of the ad hoc committee for the parade, would not be subject to the Sunshine Act, whereas the second one, where it is based on ordinance, where they are making recommendations back to the elected officials, that would be subject to the Sunshine Act. Then we move on further in the definition, and we find the phrase exercises authority to take official action. Okay, well, what exactly does that mean? Again, another somewhat subjective phrase, but not nearly as bad. Exercising authority to take official action means that they have been granted the mission to take action on behalf of the government body. And then we look further at the definition of official action, which interestingly enough, you can find in the Sunshine Act. You go to the definition section and it describes what official action is. In there, it includes the phrase making recommendations. Okay, now you're thinking, well, why would you have a committee that doesn't make recommendations? But interestingly, we find that out there. And for instance, one very real example would be we're going to appoint a fact-finding committee. Okay, we want you all to go out and gather information on this particular topic that's currently before the board and come back to us, not with a recommendation, but just with information so that we as a board can educate ourselves on this matter before we go about voting on it. Okay, now the gatherings of that particular committee, that's purely fact-finding, that isn't taking any official action, whether it be in the form of votes or just making recommendations, would not be subject to the Sunshine Act, okay, because it's purely fact-finding in its nature. So, there I think is a very real-life example. Another one, unfortunately, it's sad to say, but, I've been there myself, is that occasionally elected officials will appoint a committee so that an issue just goes away. All right, let's say that it's particularly sticky. It's not necessarily that critical, but if we vote for it, a lot of people are going to be upset. If we vote against it, a lot of people are going to be upset. If we do nothing, then we'll just kind of, kick the can down the curb. The best way to do that in some instances is just to appoint a committee. And, we're not giving you any authority. It's okay with us if you never meet, but the best way to handle this is we're just going to appoint a committee. Now, if that committee gathers because they are not empowered to take any official action, yeah, there's a good chance they would not be subject to the Sunshine Act. Okay. And, it sounds kind of strange describing this, but sometimes from a pragmatic perspective, that's what happens. So there would be an example of a committee with their gathering. They would not be subject to the Sunshine Act because they are not empowered to take any official action. Okay, now that's what's in the act. And okay, question has popped up. Can the secretary treasurer, who is not a supervisor, not elected, make recommendations to a supervisor outside a public meeting without violating it? Yeah, I think conceivably they can. It's just that the actions that subsequently would be taken by the supervisors, by the elected officials, would need to occur in a public setting. Okay, so as secretary treasurer, you're an appointed official. And the recommendations that you're making, typically they're going to be documented in, like the profit loss, the expense statements and so forth. They're all public records. Okay, so you provide a recommendation. If the supervisor subsequently act on that recommendation, that has to occur in a public setting. So I think you would be okay. You're not a committee per se. All right, that's a good question. All right, so this is what the Sunshine Act says, what we've just covered by looking at the language in the act itself. With any act, there is also case law that typically accompanies it. Now, admittedly, there's not a whole lot of case law when it comes to the Sunshine Act. We just don't see a lot of litigation over the years. But there was one case, well, there's a couple cases, but to cover this subject, whether or not a committee would be subject to the Sunshine Act, there's a case out there called Ristow versus Casey. This goes back to the administration of Governor Robert Casey, a couple decades ago. And the Ristow decision provided some excellent language in it that shed some further light on the issue as to whether or not a committee would be subject to the Sunshine Act. So let's take a look at the language in this court case, Ristow versus Casey. First offhand, the court asked the question, does the committee have decision-making authority? And like we said earlier, there are some committees that simply don't. They're fact-finding, or they haven't been tasked with any decision-making authority by the appointing authority. Okay, then it asks the question, are the members appointed by the board and are they authorized to act on its behalf? Well, other than the example that I have given, you might ask the question, why would you have a committee that isn't appointed by the board, and why wouldn't they be acting on the board's behalf? And I like to use the example of public libraries. Now, all across Pennsylvania, you find a variety of governance models that are used by public libraries. You can have some that clearly are a subunit of the governmental jurisdiction. But then you find other public libraries that are completely independent of the governmental jurisdiction. And let's say that you have a committee appointed initially by the elected officials to oversee the operations of the public library. But over time, it becomes self-appointing, self-governing. And the example that I would give is that if there is a vacancy on the library board, the board itself is responsible for going out and finding a volunteer to fill the vacancy. The supervisors, they really don't want anything to do with it because it is, a rather independent entity as far as they're concerned. And, the board, they can trust the library board to kind of take care of itself. So in that instance, the members are not appointed by the board of elected officials, but rather they're appointed by the board, the remaining members of the library board. And then are they authorized to act on its behalf? Well, not really, because of the independent nature of the public library. That doesn't come back to the elected officials in any way, okay? Because, all their fundraising is independent. They don't rely on township funds for anything. There's no real nexus between the operation of the library and the operation of the township or borough or wherever the library happens to reside, okay? So in that instance, they would be independent. The board is self-appointing. It doesn't meet the criteria that, in this case, the court was looking at. But let's say they are. So we move on to the next question that the court asked. And in this particular case, are the recommendations made by the committee pursuant to statute, ordinance, or regulatory authority, whereby the result is the enactment of laws, policies, or regulation? Okay. To me, that really cuts to the quick here. This is the most important thing that I look at when asked, is this committee subject to the Sunshine Act? Because that committee, in turn, goes back to the elected board and makes recommendations as to a course of action. Okay, well, what is that course of action? And is it subject, is it guided or determined by statute, ordinance, or regulatory authority? Meaning, is the analysis and recommendations made by that committee prescribed by law? Okay, so if we go back to the original example of the girls softball team, that ad hoc committee, you're not going to find a statute. that says you have to have a parade, you have to have a gathering at the township park. But yet, if we look at other activities, like the Public Works Committee, the Streets Department, law enforcement, and the like, you're going to find quite a few statutes and ordinances that say these issues must be prescribed by law, and the township or the government jurisdiction is responsible for ensuring that this action takes place. So hopefully you can see the distinction here. If you can take the activities of that committee and find a nexus with a statute or ordinance, or maybe even federal law, then that nexus is determinative that the gatherings of that committee should be open as prescribed by the Sunshine Act. The public should be allowed to attend and, where appropriate, provide public comment and the like. Okay. Now, all this being said, looking at the language in the Sunshine Act itself, looking at the court's language in Ristow versus Casey, if you're still not sure as to whether or not your committee's meeting should be open to the public, our recommendation is lean towards transparency and open it up, okay? And it's for a couple of reasons. First offhand, I'm with the Pennsylvania Office of Open Records, okay? It's basically, we are the state's transparency office, and naturally, we're going to say lean towards transparency. But there is also a more pragmatic perspective on this. If you decide that you don't want to go through the inconvenience of opening up your meeting, meaning advertising, finding a room that's big enough, listening to the public and their comments and so forth, if you decide to close the meeting, if there's a citizen who believes you are in violation of the act, they can take you to court where you have to pass what I call the straight face test, meaning you have to stand before a judge and explain with a straight face why you did not allow the public into your committee meeting. And if the judge disagrees with your reasoning, they can impose sanctions that quite honestly can be very, and we'll talk about that to the end. So I think you need to make an informed decision and weigh the benefits versus the costs of what it means to open up your meeting and what the potential sanctions are if you don't open up the meeting and you're hauled into court because of it. Okay, so, all things that I'm not going to say you must open up your committee meetings, because there very well may be circumstances that would allow you to not have to do that. And maybe you're willing to take the chance, but from my perspective, I'm not sure that's a chance I'd be willing to take, but I'm not the one sitting in your chair. Okay, but bottom line is, if you're unsure, lean towards transparency to keep yourselves out of trouble, even though it may be a little inconvenient for you to do so. Okay, then we need to answer the question, is it a meeting? Okay, and it so happens that we look at the Sunshine Act and it defines what a meeting is, okay? And there's certain considerations that have to be addressed here. First offhand, is there a quorum? Okay. Now, this is a quorum of the committee members. People will ask, well, do we need a quorum of the elected officials for it to be considered a public meeting? And the answer is no. There's no nexus between the status of a public official and the makeup of the committee itself. You can have a committee with no elected officials on it, and it is still subject to the Sunshine Act based on the criteria that we just finished talking about, okay? There is no requirement that you must have any, much less a quorum of elected officials on a committee in order for it to be open to the public, okay? Otherwise, we would just appoint committees without a quorum of elected officials and conduct all kinds of deliberation and public and official business. and we get away without ever having the public present. And, admittedly, unfortunately, there are some government entities that have tried to do that. And ultimately, they get called out and, again, hauled before a judge, and they, have to perform that straight face test. And oftentimes they fail. Okay. I want to mention also that committee members can phone in. Okay. But this doesn't apply to all forms of government in Pennsylvania. Let me think now. The Borough Code and the First Class Township Code dictate that a quorum of elected officials must be physically present in order to conduct official business. Once they have reached a quorum, then any additional members can phone in and be part of the deliberations and any official business. One of the conditions of phoning in, and this would include also the use of online platforms like Zoom or Teams or Skype or whatever. The connection must be direct, meaning if I'm sitting in the room, I need to be able to hear Fred's discussions, his comments, and he needs to be able to hear everyone else in the room. Typically a conference call set up or online, like we were describing. You cannot have someone sitting there with a cell phone at their ear relaying back and forth, and I would not be able to hear Fred's comments and he would not be able to hear me, because the potential is there that they would be filtered by the person acting as the intermediary. The communication must be direct. Okay, now if you're a second-class township, if you're an authority, if you're a school district or the like, you do not need a quorum physically present. You do need a quorum through a combination of who's in the room and who's participating online, okay, in order to conduct official business. But you do not have to have a quorum physically present. Okay, then that begs the question, can we have a completely online meeting? Okay, our position here at the Office of Open Records is no, that you must have a physical presence in order for the public to be able to address their public officials directly, face to face. And that's based on our interpretation of the language of the Sunshine Act, as well as the comments of state representatives and state senators made at public hearings related to the Sunshine Act when representatives of our office have appeared to testify. Okay, it is their belief that the Sunshine Act requires a physical meeting. You cannot have strictly online public meetings without the public having the opportunity to physically address their public officials. Now, full disclosure, there are organizations in Pennsylvania that do not fully agree with our position on this. And until the issue, if and when it is ever litigated, the jury remains out on that, okay? This is purely our legal interpretation of what the Sunshine Act says and what the intent of the legislature is. There are other organizations that, like I said, they believe that you can have purely online meetings. We disagree with that. Okay, next question that needs to be answered to determine whether or not it is a meeting is there deliberation? Quick definition of deliberation is that any discussion that could lead to a decision. Okay, what's a decision? Well, it's a vote. Okay, so any discussion that could result in a vote of government business for our jurisdiction would be subject to public scrutiny. Even if a vote is not taken, if you're discussing business of the government unit, That's deliberation. Thus, the gathering would be considered a public meeting and subject to the provisions of the Sunshine Act. Okay, so the question comes up, and we get this every now and then, phone call. Okay, say, I saw my township supervisors down at the restaurant the other morning. They were having breakfast. Isn't that illegal? Well, the answer is no. It depends on what they're talking about. If all they're talking about is the weather or their families, or maybe they're talking about just how great it was to have the parade and the gathering at the park for the girls softball team, that's not really township business per se, and they're allowed to get together, and there's nothing preventing them from having breakfast together. Now, if they start talking about township business and, how we're going to vote on this particular issue, or, concerns that they have or whatever, then that does rise to the level of deliberation, and they've got a problem there, because that should be occurring in a public setting. So just by them being in the same room together, it is not, there's nothing illegal about that. Okay, it just depends on what they're talking about. And then finally, I want to caution you about email meetings, okay? And this comes up periodically, usually when a new board is seated at the beginning of the election cycle. And what happens is that, someone is elected chairman, maybe they come from a business background, there's issues that need to be addressed, and they think, well, at work we just handle this with email, so this is what we're going to do. Okay, if you're talking about public business of a policy level, you are violating the Sunshine Act. Even if all the emails are not, all inclusive, maybe it's to one member of the board at a time, it nevertheless represents de facto deliberation, and you're more than likely in violation of the act. Okay, now you can have email discussions about administrative level issues. Okay, so what's the difference between policy and administrative? Well, let's say that your board at the previous monthly meeting voted to approve, we're going to spend $200,000 on street paving in the borough this year. Okay, so they voted, they approved the expenditure. Okay, now the question comes up, well, what streets are we going to pave? Okay, and it turns out that, staff has submitted its recommendations. The vote to pave the streets has already occurred. Okay, the policy level decision has taken place in a public setting, completely legal. Now we have to work out the details on what we previously approved by vote. So that is administrative in nature. It involves discussions with staff, discussions amongst ourselves as elected officials, that we can take care of with email. Okay, because the policy level decision has already been made. So the administrative level decisions, working out the details, that you can do using email. Okay, I just caution you though, don't try to disguise policy level decisions as administrative in nature. It's one of those things where once you're doing it, you kind of know, okay? And it's like any law, if you try to outthink the law and work out shortcuts around it, you're going to get caught, okay? Sooner or later, it's going to come out, and the results typically aren't pretty. So my recommendation to any public official, and this, occasionally they will call up, well, what if I do this? And you can kind of see how their minds are working. They want to take the easy way. And sometimes with government, there just is no easy way. And the Sunshine Act is no different. Don't try to outthink the law, because sooner or later, you're going to get called out on it. And you're either going to be subject to civil sanctions, or if it's particularly egregious, there could be some criminal sanctions involved as well. So just, be a good public steward, follow the law, allow the public to witness and participate in your deliberations, and you'll be fine. Okay, moving on. What is not a meeting? Well, I just got done describing the whole administrative action versus agency business scenario. So hopefully we're clear on that. Then we have things called work sessions, conferences, and retreats. Okay. Work sessions. I think school boards are probably the best example that we can use here. School boards typically will have their monthly business meeting that's open to the public, and then they'll have work sessions. Okay. And this is usually a monthly meeting that is closed to the public, where they are listening to presentations by staff, maybe superintendents, assistant superintendents, deputy assistant superintendents and the like, where they're getting updates on current initiatives, projects, and the like, so that they can become educated. And when it comes time for the next public meeting, where maybe this issue comes up for a vote, they can make an informed decision. Okay, now the communication is primarily one way. You have the staff making presentations to the elected board members. Now, the board members can turn around and ask questions of the staff. They can have a conversation, okay, to clarify issues and the like. What they cannot do is discuss the merits of the presentation among themselves as elected officials, because that rises to the definition of deliberation. And whenever you deliberate, if you remember, that needs to occur in a public session. It's thus open to the provisions of the Sunshine Act. So as long as the board, behaves themselves and doesn't discuss the merits of what's being presented to them amongst themselves, you can have these work sessions. Okay, then you get into conferences, and this is, where you have advocacy groups. Maybe it's the township supervisors, maybe it's the Boroughs Association, the Municipal League, or the like, that put on conferences so that the elected officials can go to these gatherings and find out, the latest practices for pension funds, or what's the best asphalt mix to use these days for potholes for the Public Works office to use. Or, maybe there's one of these excellent presentations about the Pennsylvania right to know law. So they want to go and find out, okay, how do we make sure that we have a good open records program and the like. Okay. Again, there's no problem with attending these conferences for educational purposes, as long as the supervisors don't go in the corner of that conference room and start discussing the township business, or the borough business, or the school district business and the like, because again, you end up deliberating. Okay, so at these work sessions, at these conferences, at these retreats, it's fine for these public officials to gather, as long as there's no deliberation and no decision making taking place. Okay. All right. So let's talk about public notice, the first leg of the stool. Let me get a sip of coffee here real quick. Okay. Under the Sunshine Act, public notice is required that at least 3 days in advance of the first regular meeting of the year. And then you would need to also give notice as to any remaining meetings for the calendar year. Okay, usually what happens is there's an organizational meeting at the beginning of the year. So at least 3 days prior to that, there needs to be a legal notice in the local paid newspaper. Okay, and a paid newspaper of general circulation for that jurisdiction. Now, with that legal notice, you put the date, time, and place of where the organizational meeting is occurring, and then typically you would put down the dates for any subsequent meeting throughout the calendar year. So if you're meeting on like the first Tuesday of the month, you take a look at the calendar, what are those dates, and you include those dates in the legal notice. Now, a couple things to clarify here. It is a legal notice. Articles don't count. Okay, occasionally you'll find puff pieces. Maybe a new board, an entire new board has been elected, so the local newspaper decides to go out and interview a couple of the new elected officials. All right, and then they happen to mention that they meet on the first Tuesday of the month. Okay, that doesn't count. It needs to be an actual legal notice. Okay, and then having it on your website doesn't count. It does not satisfy the language of the Sunshine Act. Now, you can have the legal notice as well as using your website to announce when the public meeting is, which I think is a great thing. You know, use your social media to get the word out there to the public about your operations. So yeah, put meeting times and dates on your website. Okay, but it doesn't in itself satisfy the language of the Sunshine Act. Okay, and then those free sales circulars that show up like 3 days a week in my mailbox, they don't count either. It needs to be a paid newspaper of general circulation. Okay, now you're saying, well, this is becoming really hard because of structural changes in the news media industry. We recognize that. You know, here in Harrisburg, we used to have 2 newspapers 7 days a week. Okay, now we're down to 1 newspaper, and I think it's 3 days a week, including Sunday. I don't know. I haven't subscribed to them for several years, but you know, it's becoming really hard to schedule those legal notices in advance and meet the 72-hour deadline. And all I can tell you is that if this is a concern for you as a public official, reach out to your state legislator and express those concerns. Because until the language of the law itself is changed, this is what the law says, and we all have to adhere to it. Okay, and then also the public notice of the meeting has to be posted at the meeting site itself. Okay, more evidence that there's an expectation that there will be a physical meeting because the meeting site is a physical presence. Okay. All right. What if um, there is a matter of business that cannot wait until the next regularly scheduled monthly meeting? Well, the Sunshine Act accommodates special meetings where, you know, if you've got some matter of business where you need to vote more quickly, that can't wait until next month, you can convene a special meeting. Okay, this is still open to the public, but now the public notice provision goes down to 24 hours advance notice. Okay, all the other conditions still apply. Okay, paid newspaper of general circulation for your jurisdiction. It's a legal notice. It's just that now it only needs to be posted 24 hours in advance of the actual meeting itself. And then let's say there's some emergency that's come up and the board needs to make a decision right then and there. Okay. You're allowed to do this without any public notice. The public does not need to be present at the gathering, but it needs to be a bona fide emergency. Okay, the example I use is, you know, let's say we are a small borough, we have one snowplow, it just broke down. You know, just the other day, the director of public works came in and said, hey, the snowplow is dead. All right. And the forecast says there's a nor'easter on the way. It's going to dump, you know, several inches of snow in the borough. We need to buy a new snowplow right now. Okay. And it turns out that down the road, they have one sitting on the lot. We can go, you know, make the commitment and purchase that plow and have it on the road for the storm that's coming tomorrow. Okay. Emergency meeting, everybody votes to approve it, and we go down and buy the snowplow. Okay. That bona fide emergency circumstances. Okay. In instances where you attempt to subvert the law by creating your own emergency, just remember that straight face test. You know, if you can stand up before a judge and explain why you had your emergency meeting, given the circumstances that might otherwise have allowed a public meeting subject to the Sunshine Act, you know, it's your call. It's your call. But remember, the sanctions, the pain can be significant. Okay. And then if you cancel an otherwise advertised public meeting, let's say that, you know, there's an illness and you can't get a quorum together, or, you know, weather emergency or whatever, there's no legal requirement for you to post a cancellation, But I think this is a good example where you can use your social media, where you can call, the radio and TV stations to kind of get the word out that the public meeting has been canceled. Occasionally, we will get calls from upset citizens. I planned my evening to go down to the Borough Hall for the public meeting, and I got there and the doors were locked and all the lights were out. And then the next day I called and it said, they canceled the meeting. Is that legal? Well, yes, it is. Okay. But it's a really efficient way to upset your citizens. So if you can use your social media to get the word out that you're canceling a meeting, yeah, I think that's a good thing for a responsive government to do. Okay, let's talk about agendas. This is I used to call this the new part of the law, but actually it's a couple years old now. Okay, this was enacted by the legislature a couple years ago, where it was in response to complaints from the public. Oh, excuse me. If a meeting must be canceled and we want to reschedule it, does the 3 days notice or 24-hour special meeting apply? Well, it's depends on what the original context of the meeting was. If originally it was a special meeting that you only had the 24-hour requirement and you've rescheduled it, then the same conditions would apply. If you are rescheduling the regular monthly meeting, then the 72-hour provision would apply. Okay, it just depends on the context of the meeting that would be determinative as to how many days in advance you would need to post it. Okay, so agendas. This was in response to the public complaining that, there was this really important issue that the public was kind of aware of, but we didn't know that our officials were going to vote on it that particular night, okay, because nothing was said. We had no way of knowing that they were going to sneak this through. So we want some mechanism so that we know what the board is going to be voting on that night prior to the meeting actually occurring and them taking the vote, so that we have advance warning and we can go to the meeting and express our concerns about whatever that issue is. So the legislature amended the Sunshine Act to include these agenda provisions. Let's talk about that. All agendas need to be all agencies need to post the agenda to issues that either are going to be deliberated on or voted on, official action, at least 24 hours prior to the meeting itself. Okay, and this would include regular and special meetings. Obviously, you're not going to have an agenda for an emergency meeting because it's an emergency. All right. Now, it wouldn't include work sessions because there's no decision-making or deliberation that should be taking place, conferences or executive sessions. And I'm going to talk about executive sessions here in the next couple slides. But so you've got this window, 24 hours prior to the public meeting. Okay, and we'll talk about that timeline here in the next slide, where you're limited on how you can change an agenda, but the agenda should include all issues that the board, the elected officials, or perhaps a committee, if that's what we're talking about here relative to the Sunshine Act, that you're going to either talk about or you're going to take action on. Okay, that needs to be included in the agenda. Now, people will ask, well, how detailed does the agenda need to be? The act doesn't speak to that, okay? But this is my unofficial opinion on this, okay? This is not a legal opinion. It's not based on language in the act or any court language, any case law, okay? But there is another issue in the Sunshine Act that was litigated, and the court ended up saying you need to provide enough information so that a reasonable person can deduce that you're doing it for the right reasons. Okay, now that we're talking about executive sessions with this particular court case, and I'm going to get into it. But I think it's reasonable to take that language and that logic and apply it to agendas. And you need to have your agenda items described well enough so that a reasonable person who's not familiar with the item can read your explanation and come away with, a basic understanding as to what the board is going to vote on. So if you simply say, we're going to discuss and vote on legal issues, that's not good enough, okay? You need to describe what those legal issues are, okay? Or, if we're going to discuss public works matters, that's not good enough. I, as a citizen, should be able to read your agenda and figure out, okay, this is what the board's going to talk about tonight, okay, and potentially vote on, all right? So hopefully that addresses your question. Honestly, it's somewhat subjective. It's just George's take on it, okay? If ever this issue gets litigated, a judge may disagree with George, okay? But this is what, my thinking is, given the lack of specific language in the act itself or any instructive case law at this time, okay? The law requires that you put the agendas on your websites. And if you don't have a website, but you use Facebook, well, then that's your primary social media presence. So you would defer to putting it on your Facebook page or any other social media platforms that you may be using, whether it be, Twitter or Vine or, any of the new ones that are popping up. You must also have it posted at your agency offices, at the meeting site itself, also another reference to physical meetings. And you must have copies available for the public at the meeting site, okay, to hand out to them as they come in so that they can follow the agenda as the board is working through it. Okay, now let's talk about the timeline and whether or not you can change an agenda. Well, the truth is you can. It's can only be changed within limits and according to certain criteria. First offhand, 24 hours prior to the actual meeting, you can make any changes to the agenda that you see fit, okay? Now, once you hit that 24-hour threshold, you can only change the agenda relative to what are called de minimis items, where you're not spending any money or the board is not entering into any contract, okay? So you can vote on issues where, as long as you're not doing one of those two things, you can alter the agenda in that 24-hour window. Then we get to the meeting itself, okay? The meeting is called to order. Let's say that an issue comes up, whether it's raised by the public or one of the elected officials. You can decide not to do anything and proceed with the agenda as it was presented. Or if you believe that the new item is important enough that you need to add it to the agenda so that you can discuss it and potentially take a vote on it, here's what you do. The board must make a motion first to amend the agenda. Okay, I believe this issue is important. I make a motion that we add this particular item to the agenda. Any seconds, discussion, vote to approve. Okay, when you do that, because it's official action, it gets memorialized in the minutes of the meeting, okay? Then you can proceed to deliberate and potentially take official action on this new agenda item. And that in itself may also result in memorializing the action in the minutes of the meeting, the official record, okay? Maybe you decide to discuss it and not take any action, okay? It still gets memorialized because you're deliberating on it, okay? So you've got this kind of two-step process if you feel the need to amend and add an agenda item during the actual public meeting. You can do it. It's just that you have to follow these steps. And then when you do amend the agenda, the chairperson of the meeting must announce prior to any official action taking place, why are we doing it? Okay, you can't speak in code. You've got to give a suitable explanation as to why we are adding this particular issue to the agenda. Okay, now, if you amend the agenda, it needs to be posted within 24 hours after the meeting has concluded. Okay, well then, and the posting needs to occur just like the agenda did originally, your websites, Facebook pages, business office, meeting site, and the like. So then the question comes up, well, how long does that amended agenda need to be posted? All right, well, the law doesn't say, and there's no case law. This is George talking again, okay? George has no legal standing here. But given the fact that there are 24-hour standards before the meeting for the agenda to be posted and after the meeting for when the amended agenda needs to be posted, my logic says that the amended agenda needs to be posted for at least 24 hours, okay, for this consistency. It just seems logical. Now, again, let me backpedal. If this issue is ever litigated, a judge may disagree with George, okay? But until that takes place, that's how I would proceed. Okay, a couple questions have popped up. Change to the agenda. Is it required to have public comment after the item has been announced? Yes, just like any other agenda item, and we're going to talk about public comment here in a little bit, any item added to the agenda is subject to the Sunshine Act, and that includes public comment. Okay, then next question. Does changing the order of discussion topics mean the agenda has to be changed? I don't think so. I think as long as the public has the opportunity to witness the deliberation and, if appropriate, comment on the issue prior to any vote by the board, you're okay. Changing the order of the agenda, I don't think is as critical. Okay, now, again, I don't think this has ever been litigated, so there is no case law that would shed light on that. I think, let's say it were litigated, and if the public official can provide a reasonable explanation as to why the order was changed, I think you'll be okay if it's done in good faith. If you did it in order to pull a fast one, in order to avoid public scrutiny, then chances are you're going to get caught. So I think you can change the order, but it's going to come down to why are you doing it? If it's a good reason, a fair reason, you should be okay. If you're trying to pull a fast one, maybe not. Okay, it remains to be seen. Okay, so that takes us off of agendas. Let's talk about public comment. Good timing here with the question. Okay, this is the other leg of the stool. Prior to any vote being taken on an issue by the board, you have to allow public comment on that particular issue. And then some. Okay, so commenters per the act can be limited to residents and taxpayers. Okay, so you could have someone come in from like the adjoining township and they sign up for public comment. You can shut them down. You can say, no, you're not a resident, you're not a taxpayer of this jurisdiction, so we're not going to allow public comment. Also, I need to clarify, this only applies to local government. It does not apply to state government, okay? And it's based on not what the Sunshine Act says, but actually what it doesn't say, okay? And when it comes to public comment, there's no specific mention of state government. So, the conclusion is that you do not need to require public comment for state level public meetings. Okay, so limited to residents and taxpayers, they have the right, and this is language paraphrased out of the law, but they have the right to comment on issues that are or may be before the board before any pertinent votes. Now, what's problematic is that word may, because that kind of opens it up. That, you know, you're getting ready to vote on approval of a bond issue, and someone stands up and starts complaining about the potholes on their street. Well, that may be an issue that comes up before the board at some point. So legally, they're allowed to vote on that, or they're allowed to comment on that. But there are ways around this, and I'm going to discuss that here in the next slide. And it's based on the fact that the board may establish reasonable rules for public comment. Typically, you know, here we're talking about time limits. You know, you've got 3 minutes. Everybody has 3 minutes for public comment before we vote on this, okay? Or you can appoint a spokesperson, okay? Now, I'm looking at the word reasonable here. And let's say that you've got an important decision coming up tonight. The meeting room is packed. A group comes in, they're all wearing the same t-shirts, and every one of them signs up for public comment. Okay, it is reasonable for the chairperson to approach that group and say, look, I see you've all signed up for public comment. I'm willing to guess that there's going to be a lot of repetition with your comments. What would you think of appointing a spokesperson? And rather than 3 minutes, we'll give you 10 minutes. That way, everything you want to say gets covered, and we're not here all night listening to the same thing over and over again. What do you say? Would you agree to that? And, you know, they think, well, yes, that's reasonable. We'll do that, okay? So, you know, I think next you're thinking, well, we have it written in our rules that everyone gets 3 minutes. How do we go about? Well, if you're following Robert's rules, you can set the rules aside in Robert's rules, okay? Legally, there are ways to do this without subverting the intent of the Sunshine Act or the fact that you have rules in place. Okay, so you're on firm ground here. Then you get into specific versus general public comment periods. Okay, let me check the next slide. I forget. No. Okay, specific versus general comment periods. Now, this is not in the law. Rather, it is a best practice that we're seeing many agencies embrace as a means to ensuring that public comments are kept on point. And what they'll do is, okay, this matter is now coming up for a vote, but before we do, we're going to allow public comment specifically on this issue, okay? It must be relevant to the vote we're about to take, okay? And then they allow that public comment. And then they have a second public comment period at the end of the night for just general issues, that those matters that may come before the board, where the guy who wants to complain about the potholes on the street can stand up and address the board. Okay. Again, I'm not saying this is something you must do. It's just it's been brought to our attention by a number of municipalities that we've adopted this practice and it's working out for us. All we're saying is maybe you want to take a look at it as a potential best practice that would work with your particular entity. Okay. And it kind of solves that problem of keeping things on point. But be very careful about shutting anybody down during public comment, because there is and has been litigation about abridging someone's First Amendment rights when you say, we're not allowing you to comment on this issue because it's not relevant, okay? And the federal courts have found that in those particular instances, the boards were violating the First Amendment rights, the free speech rights of the public commenters. Okay, let's talk about executive sessions mentioned earlier. Executive sessions are gatherings of the elected officials and anyone who has a need to know reason for being part of the gathering that are held outside of the public eye because of the sensitive nature of the discussion. Executive sessions can be held before, during, or after an open meeting, or they can be announced at a public meeting for a future date and time. Okay, but the public would not be present at these executive sessions. When announcing the reason for a public meeting, the board must give the complete reason. Okay, you can't just stand up and say personnel issues. You can't just stand up and say legal issues. And there is a court case that's instructive on this. It's called the Reading Eagle, or the Reading City Council versus the Reading Eagle. The Reading Eagle is the local newspaper down here in Berks County. Okay, and the council was doing this. They would say, we're going into executive session for personnel reasons. Okay, Reading Eagle took them to court. The court agreed with the newspaper. And in the language of this, it basically, and kind of paraphrasing here, and I kind of alluded to it earlier with the agenda issue, the court referred to a court case in Tennessee, and it came back, but basically, the court said, look, when you give the reason, or when you're going into executive session, you are basically taking the public's trust by meeting outside of the public eye. So you've got to give them sufficient explanation to satisfy their public trust that you're meeting in secret for a legitimate reason. Okay, a lot was said there, real mouthful. But basically, it's like you've got to provide enough of an explanation that I, as a citizen, believe you're doing it for the right reasons. So if you're going into executive session for personnel reasons, you would say it's so that we can consider the applicants that have been submitted for this particular vacancy that we're looking at filling. Or we've got a disciplinary issue involving one of our employees. We want to hear out both sides of the issue to determine whether or not it's appropriate to suspend this employee. Or we've got litigation involving this company suing the city, and it's in common pleas court right now. So we want to hear from our solicitor on potential legal strategies. Okay, enough of an explanation so that we know we're going into executive session for a legitimate reason. And I, as a citizen, am satisfied that I've heard enough there. Okay, now, when the board meets in secret in executive session, there's no requirement that they take minutes. And if they do, the Pennsylvania Right to Know law exempts those minutes from public disclosure. Okay, it's an exemption within the Right to Know law that executive session minutes can be withheld from the public eye. The board cannot take official action during executive session. Now, they can resolve on a course of action that they want to take. They can kind of poll themselves informally. What do you think we should do here? But any action resulting from deliberation in secret must take place in the public eye. So let's say they meet for a potential disciplinary issue. They decide we're going to suspend this employee for 3 work days. They adjourn the executive session, come out into public session, reconvene public session, and then they must vote. We're going to suspend this employee, and they name names, for 3 work days based on a disciplinary infraction. Okay, and they would make that, as part of the official record. Part of the official record. Votes or motion, second, vote, and the like. Okay, so no voting during executive session. Otherwise, it's not official and it wouldn't hold water. Okay, and then why can you meet? What reasons are there for meeting in executive session? Well, personnel matters, like I mentioned earlier, hiring, firing, discipline, okay? Only for specific positions or specific staff, okay? If you're you cannot go into executive session to discuss hiring policies or disciplinary policies, okay? That discussion must occur in public. But if you're talking about hiring for a specific position or hiring a specific individual, you can do that in executive session. If you're talking about disciplining a specific employee, executive session. if you're talking about what should be the discipline for a specific work rule infraction, no, that's a policy matter. That has to occur in public because it's more HR policy as opposed to a specific action against a specific employee. Discussing labor negotiations. Yeah, you've got a union shop, contracts up, you're getting ready to, formulate your negotiating strategy. You can do that in executive session. Consider the purchasing, leasing, or selling of property. Okay. Yeah, you can do that in an executive session so that you're not showing your hand on, what price you're willing to settle for after you negotiate or during negotiations. Now, the law does not mention the term selling, but there is an unpublished Commonwealth Court decision where the court concluded it's reasonable for a board to go into executive session for selling property as well as purchasing property. Okay, consulting with counsel about litigation. Okay, again, legal strategy sort of stuff. You would not discuss that in public. Avoiding violating privilege or confidentiality. Yeah, attorney-client privilege. Again, that premise that conversations between counsel and their client on sensitive matters is covered by attorney-client privilege, thus it is private. Thus you can do that in executive session with your solicitor. Okay, discussing university admissions standards. Yeah, I don't know. I wasn't around 70 years ago when they came up with this language, but apparently they felt that was important. Discussing emergency preparedness. This was added more recently, and it has to do with like homeland security issues and the like, where in order to avoid any potential risk to the public, you can discuss certain matters of emergency preparedness in executive session. All righty. I've mentioned violations of the Sunshine Act. Okay, how does this all work? Well, let's say you're in a public meeting and the board does something that a member of the public who's present takes exception to. They can stand up at any point and say, I believe this is a violation of the Sunshine Act. And that's pretty much it. They can explain why or whatever, but by doing so, they are not out of order, okay? They can bring it to the board's attention and they put the board on notice. That's sufficient, okay? But you can't say, sit down, you're out of order, okay? Because they're not. The Sunshine Act specifically allows them to do this. Okay, now what if the board agrees? It's like, yeah, I think you're right. We did just violate the Sunshine Act. Well, the board right then and there can cure their violation. They can go back and make it right by, taking a new vote or, doing whatever they need to do to correct the violation that they perceive has occurred. Okay, they can cure their own violation and no harm, no foul. But what if the board disagrees? Well, they can proceed as they were intended to, but then the public within 30 calendar days can take them to court. For a local agency, they would go to their county court of common pleas and seek the appropriate legal relief. That could be an injunction. It could be corrective relief. It could be declaratory relief. It just depends on the specific situation as to what sort of relief they would seek out. Typically, the judge would convene a hearing, and here's where that straight face test comes into play. The parties would have a chance to explain their positions. If the judge agrees with, what occurred in the public meeting, well, then that's the end of it, okay? We're done here. However, if he disagrees and finds that the board is in fact in violation, they have a fairly broad degree of discretion. They can simply say, yeah, there was a violation, don't do it again. They can say, yeah, there was a violation, I'm going to void this specific vote. Or they can say, I'm going to avoid the entire meeting. And, we've seen that done in recent history. If they believe it was particularly egregious, they can take sanctions against the board. And we've seen a couple interesting examples here in recent years. The big one has been, I'm going to require that the board receive training on the Sunshine Act. and they will refer them to us here at the Office of Open Records. We'll conduct the training, and then we send a letter to the judge saying that, you know, all these people were present, they received Sunshine Act training. Or they may levy fines. Okay, now, the Sunshine Act allows a judge to fine each public official up to $1,000 for the first violation, up to $2,000 for the second violation. It's important to note that the fines must be paid out of the public official's pocket, not the agency. The agency is not permitted to pay the fine. So each public official found guilty of violating the Sunshine Act can be dunned the $1,000. So you can see how this gets pretty painful. And this doesn't happen a lot, admittedly. It usually needs to be a pretty egregious violation for the judge to go ahead and do that. But, you know, it's not to take away anything from a county judge, but you catch, you know, if you've ever sat in county court and you catch a judge on a bad day, you know, who knows what's going to happen. But that's what a judge can do, so it can make your life very painful for a little while. Okay, then let's just finish up with some miscellaneous issues related to the Sunshine Act. You must produce meeting minutes recording the board attendance and who voted for and against, meaning that typically if a board, you know, does an up or down vote, that's all that gets recorded in the minutes. However, if each member is polled, then each member's vote must be recorded in the minutes. Now, that's what the Sunshine Act says. Typically, the codes, the borough code, township codes, and the like, get into greater detail as to what must be included in the minutes and so forth and so on. So the two acts kind of work in concert with each other as to how votes are recorded. Now, meeting minutes are considered a public record under the Pennsylvania Right to Know law and must be produced in accordance with the provisions of that. Then we come up to the next issue. Public meetings can be recorded by members present at the meeting, and there is no requirement that they tell you they are doing so. So before I enter a public meeting, I can take my cell phone, set it to record, put it in my pocket, and not tell anyone. What I recommend is that the board chairperson, when they're doing the initial announcements, say something to the effect that it's also possible that this meeting is being recorded. There's no expectation of privacy. It's not a violation of the Sunshine Act, and it's not a violation of the Pennsylvania wiretap law, okay? And if the municipality itself is recording the meeting, that recording is also considered a public record until such time that it's destroyed or deleted or disposed of in some way, okay? It is also available to the public. And what a lot of municipalities do is they'll post that to their websites, or they'll live stream it or whatever. Or we're seeing Facebook streaming these days for a lot of public meetings, okay? They're public records, okay? So they are accessible under the Right to Know law. Okay, so that brings us to the end. So if you have any further questions, now's the time to get them in. But in the meantime, I want to notify you as to the availability of a number of resources that you're going to find on the Office of Open Records website, okay? You know it's coming if you sat through one of these webinars before. This is the best government website you will ever see, okay? It is updated 6 days a week with new information on Pennsylvania's Right to Know law, on any issues related to the Sunshine Act, decisions made by the Office of Open Records or courts throughout Pennsylvania, any information related to government transparency, training resources are out there. We have guides for citizens relative to the Sunshine Act. There is a page of FAQs specifically related to the Sunshine Act. If you need a copy of the act itself, it's there. You can download it for free, okay? Not necessarily a hard act to read and understand. There's, you know, if you're interested in government transparency in general, you can subscribe to our Twitter feed Every morning between 7 and 8 a.m., we will wake you up with all the news that's fit to print that day on government transparency. And you can become a real transparency geek. And who knows where that'll take you. But yeah, take a look at our website for any information that you might need. Finally, don't be shy about reaching out to us. People do it all the time relative to the Sunshine Act and the Right to Know law. They call the office, talk with our administrative staff, or they'll shoot an email in, and we're more than happy to help you out. You know, we can't provide legal advice to you, okay? That's something between you and your attorney, because oftentimes we find ourselves, you know, on one side of the issue or not, and we have to maintain, you know, a fair posture on all of this. We have no enforcement authority when it comes to the Sunshine Act. Rather, that's up to the judge, okay? We are tasked through statute to provide training and guidance, so that's the best we can do for you. But we'll do the best we can with that. So I haven't seen any other questions pop up. I want to thank you for your participation here today. We'll see you again in 2 weeks with our next webinar. I understand some nice weather's on the way, so I hope you have an opportunity to get out and enjoy it this weekend. Thank you. We're signing off now, and everyone take care.